got the construction and the regions under control, so hopefully we won't have any pounding going on. The second case we have is 25-0062. Is it Psyops?
Psyops.
Psyops? Okay. Psyops versus Psyops. Counsel, prepared to proceed?
Yes, Your Honor.
All right. Please approach.
May it please the court. My name is Richard Sierra. I am the attorney for the appellant, the plaintiff below, Joan Psyops, who is the daughter of the defendant and the appellee, Nancy Psyops. Your Honor, this is not a complicated case. In fact, I believe all of the material facts.
Before you get started into your arguments, the first thing that's raised here is obviously a jurisdictional issue.
Yes, sir.
So not give us an ability. We would be considering whether you can dismiss the appeal, which I think the appellee spent most of their brief on. So the final judgment was issued on March 28, 2023. You would agree you did not timely appeal that final judgment. I think you admitted in your brief you could have done that as a partial final judgment.
I believe the order was interlocutory because it did not resolve the counterclaim.
So I was going to ask you, what did it not resolve?
Well, it reserved jurisdiction to determine damages, and it said
Which
damages.
was simply attorney's fees and costs, correct?
Well, and whether or not my client would have to transfer her interest in the real estate to the defendant.
So is that your distinction as to why there was more judicial labor needed, that the ownership interest, even though the partition action was denied?
The counterclaim made a general demand for damages. This was a compulsory counterclaim. The claims were interrelated. The defendant asserted the breach of the agreement as defense to the case, as an affirmative defense, as well as bringing the counterclaim. So they're an interrelated counterclaim, and the defendant made a general allegation seeking damages. Did not seek special damages, did not seek specific performance or the transfer of my client's interest, but made a general claim for damages. After trial, the court found that my client was in breach of the agreement because I believe the court said because she failed to transfer her interest to her mother in August of 21, before the mortgage ever got satisfied, that was a breach. And the court reserved jurisdiction to determine damages of legal fees and costs, or legal costs and fees, and reserving jurisdiction to determine whether or not my client would be required to quit claim her interest to the mother. So there was no claim for attorney fees. So it's unclear if the trial court saw attorney fees as an element of damages, as a kind of damages. I understand under McGurn v. Scott that attorney fees and costs are generally an ancillary matter and would not make the judgment non-final. But it also included that requirement. But if the court sees attorney fees and costs as an element of damages as opposed to an ancillary matter, it's kind of those are your damages. I'm not sure, and I'm not clear on that point. But I think the fact that the court reserved jurisdiction as an element of damages, whether or not my client would have to quit claim her interest to her mother, rendered it non-final. And the whole question.
So that is a main focus, that you think the court really didn't decide.
Correct.
Essentially,
The court,
did he?
right. I cited the Rollins. I think it's Rollins Fruit Company v. Wilson. That when a court does not resolve the issue of damages and conclusively issue it, that the order is non-final, that the order is interlocutory. In that case, the court granted a motion to dismiss after trial and reserved to determine the amounts that the seller owed the buyer in a real estate transaction. The court found that order was not final, was not appealable, and I believe that's the case here. And the wisdom of that policy is, Your Honor, if all that happened at trial was my client was denied the opportunity to partition the property, but kept her interest in real estate, she's not going to appeal. It's not, but the final order, which the last thing the trial court did was determine that my client no longer owned an interest in the real estate. That was the final decision rendered by the court, directing the clerk to record the
So that's why you argued there was still labor to be involved. Because of that.
Yes, because the final judgment after trial did not conclude the judicial labor. In fact, the defendant scheduled an evidentiary hearing to be heard to determine what the damages were. So there was a lot of judicial labor to be done. So I don't believe it was a final order. I think it was interlocutory. I do believe he could have appealed it as a partial final judgment, but that wasn't my client's decision, and I cite to the Saul v. Bassey case that, that's not an obligation on the part of my client. But the case, Your Honor, what it's about is simple, is the material facts are undisputed. They were in a partial summary judgment hearing. The trial court made a determination. The first important material fact is that on January 8th of 2021, the plaintiff and defendant entered into an agreement. It was, I believe it was titled Buyer and Co-Signer Real Estate Purchase Agreement. And there's no dispute, all parties admit they entered into that agreement. It's a brief 3 or 4 page agreement setting forth the terms under which my client would co-sign a loan to purchase a home. The defendant sought to
At
purchase
some
it.
point, the mother refinances, correct?
Excuse me?
At some point, the mother refinances.
I believe she satisfied the mortgage.
Or she satisfied the money. And so why, I'm trying to figure out equitably and in fairness, why the daughter would want to do this here in this case to the mother to make her sell the home and take the proceeds.
Well,
Her portion of the proceeds. And I understand co-signing is a portion of consideration, so I understand that.
Sure.
I'm just, I'm
the rationale, I mean-
Yeah, I'm looking at the rationale, and that's what the trial court judge is looking at.
And there's some evidence in the court file, and we filed affidavits. The history between mother and daughter is not good. Okay, it was a painful relationship, and my client did not want to do this. She was approached and felt browbeaten by the family to co-sign. She didn't want to do this for her mother. And she was assured that it's just a brief period of time for which you got to co-sign. And of course, my client, when you co-sign something like that, it does affect your credit. Not only does my client obligate herself to the debt, but if she goes to get a loan, credit reporting agency, and she testified at trial that did happen to her, where she was denied loans. But more importantly, she felt that, these were promises made to me, and I'd like to enforce them. And I just want to see, she kept her promise, and she wanted her mother to do the same to her. And the agreement made it clear.
Hold on a second. There was a summary judgment decision. There was partial summary judgment, correct? And then the breach of contract claim and the partition action went to trial?
Yes, so the summary judgment knocked out the equitable claims because everybody agreed there was a written agreement. There was
Okay, so let me
buyer and co-sign real estate.
stop it again. Was there a transcript of the proceedings?
No, not of the trial. Because the issue, Your Honor, everybody agreed that there was agreement. Everybody agreed the mortgage didn't get satisfied.
Oral evidence came in, which I believe is part of your argument.
Yeah.
And so how?
It's not, I don't argue the parole evidence supports the claim. I argue the parole evidence rule prohibits the testimony of the mother saying her interpretation of the agreement is relevant.
Hold on. How do we know that was objected to below? About a transcript?
Well, I certainly argued in the motion for rehearing that was raised in the court. There's plenty of argument in the motion for rehearing about the motion, about the court's reliance. But to what extent it affected the court, I don't know. The court's decision can be read and determined. But the undisputed fact is the mortgage was not satisfied until January 5 of 2022, approximately 1 week after the defendant was served with the partition action. The agreement clearly states if the mortgage is not satisfied by April 30th, then my client has the right to sell the property. And the proceeds, if there's any loss, the defendant was to bear them, and if there's any profit, the parties are to share in them equally. And so I think the terms of the contract are fairly clear. The court's determination that my client was in breach of that contract by failing to pay the mortgage in August, I simply, there's nothing in the contract that obligates my client to do that. Interpretation of the contract is a pure question of law. This court can read it, and I just don't see how determination from the fact that my client, when the mortgage has not been satisfied, is in breach of contract can be upheld. The second decision by the trial court that we feel should be appealed is a decision that the contract is inconsistent with her right to partition. I said there's certain material facts are admitted. The court determined, both at the partial summary judgment hearing and in the final judgment, that the parties were joint title holders and that the warranty deed between them My client was a 50% owner of the property. So the right to partition is an incident to the ownership, and the contract, far from prohibiting a partition, argues that, or asserts, or the agreement is, that if the mortgage is not satisfied or refinanced by April 30th, the property is to be sold by my client, and if there's any profits, then they would be shared. And there's no guarantee there would have been profits. Now, after we filed the action, the defendant satisfied the mortgage. So whether or not there would have been any money, but my client wanted the property sold and wanted the obligation offered credit. So we believe the trial court erred on those two issues. We believe the court should reverse and direct the trial court to proceed with the partition. I understand the mother has been in possession of the property and she's paid mortgage, taxes, insurance. All of those things can be addressed in a partition in a claim for special equity. We're not saying that she's not entitled to special equity. There's a whole body of case law for addressing partition actions and how parties can make claims. What amounts my client would be entitled to would be determined in the accounting that's done in a traditional partition action, where traditionally the court will order the property sold, the debts to the property are paid off, the proceeds are held by the court, the parties are permitted to make their claims for any kind of special equity. If the mother wants to go to the court and say, I paid the mortgage and the taxes and the insurance, and I paid for the maintenance, she can make those claims. Similarly, my client will be able to make a claim. The mother's been in possession of this property all this time and would be entitled to seek claims for attorney fees, claims for rent, her share of the rent that she would be entitled to. In fact, I do believe the mother was renting the property. All of that should be done and handled in a partition action, Your Honor, and it would be consistent with the agreement that they entered. And I think the trial court's decision was inconsistent. I don't have any further argument. I'll save the rest for rebuttal if the court is fine with that.
Very good. Thank you.
May it please the court. Christopher Eads appearing on behalf of the appellee, Nancy Sayos. I am confident the court has went through the briefs, and so I'm not going to get in much to the record as well as the statement of the facts in the case. In general, Your Honors, this case centralizes on time. The appellee's two main arguments are focused on time. First, that the notice of appeal filed by the appellant was untimely. This court has said numerous times that in order to confer jurisdiction upon the appellate court, the order, in this case the final judgment following trial in March of 2023, the appeal must be filed within 30 days pursuant to Rule 9.110B.
Were there still issues to be decided after the initial final judgment?
No, Your Honor. All the judicial questions have been answered with regard to the partition.
Had the ownership been decided?
I believe that's an enforcement issue. In particular, while had we had an opportunity to respond to the reply brief, would have mentioned, for example, several enforcement statutes. As in this case, this was deemed by the trial court to be the appellate holds a security interest and nothing more. Now, in practice in Florida,
But her name was on the title.
that is correct, Your Honor. Looking specifically at real estate then, Rule of Civil Procedure 1.570 often gets referenced with enforcement of judgments regarding real property, specifically contempt, Section C. However, Section D of that statute talks about an order can act as a deed, conveying title to real property, and the appellee believes that the only issue left, particularly in this case, following the final judgment, was the determination of damages as in breach of contract, and the question of whether or not the appellate should sign a quitclaim deed. But that was only to avoid a cloud on the title. It was not to remove her ownership because that had already been decided. That was simply to avoid having to file a quiet title action in the future. So the judicial labor had concluded with regard to the partition action. Simply remaining was enforcement. Now,
She didn't miss the deadline to satisfy the mortgage, correct? In the
Right.
initial contract, is that correct?
Well, first, the deadline on the contract itself was.
I know there's two different dates in the contract, and there's two different dates, but she did miss both of those deadlines, correct?
Correct, Your Honor, but looking at the record, that deadline, so to say, was consistent with a sale to the sister of the appellate of the New Hampshire property, and being family members, everyone was on board and knowledgeable about that. 2021 was a time in which there were lots of postponements, lots of things closed. So the postponement of that closing was known by everyone, and looking at
But
time.
That's testimony evidence outside the language of the contract, correct?
Correct.
That's what you read. So, under the plain language of the contract, why shouldn't we just enforce that language? I mean, we're not kind of in the business of rewriting contracts.
Well, and that's the main dispute in this case, Your Honor. The appellate is looking to enforce strict contract principles. However, that's adverse to the action that the appellate chose to file. The appellate, if the appellate believed the contract specifically controls and must be strictly enforced under the parole evidence rule, then logically, if the deadline had passed and the months after the deadline had passed, leading to August, then the action that could have been filed, wishing to keep it in the plain language of the contract, would have been a breach of contract.
Does the absence of a record impair our ability to fully evaluate the arguments of appellant?
Possibly, Your Honor. It was a 9-hour trial proceeding in which lots of testimony was taken. Not having that transcript, of course, makes it quite difficult for the appellate court to review what that testimony was. So does it impair? Possibly, Your Honor.
What was the basis of the judge's decision? Was the testimony was taken, correct? I mean, that was part of the basis of the trial court's final judgment, correct?
Yes, Your Honor. And that's with regard to testimony, again, to time. What was the party's intentions at the time they entered into this agreement? Now, partition law is an action in equity. It does not have to adhere strictly to contract principles, but instead to basic fairness. That gives the trial judge a little bit of flexibility to look at the party's intentions at the time of forming their agreement, not at some later date. So in this case specifically, the parties entered into an agreement in February of 2021 when they received title. And at that time, testimony, as reflected in the final judgment after trial, the appellate stated she had no interest in the property. And it's very clear, as mentioned by my colleague, that she did not want to co-sign on the loan. She was doing it simply to facilitate her mother gaining 100% title to the property and 100% ownership, which obligated her to pay all of the down payment, all of the closing costs, all of the HOA fees, all of the various expenses of the property, for which she did. Now, her intentions at the time of this agreement differed greatly from the intentions whenever she filed a partition suit. In August of that year, whenever it was time for the sale of the New Hampshire home, allowing the appellee the funds to satisfy the mortgage, the appellee hired an attorney in Ocala to prepare the paperwork necessary to facilitate the transfer. It was at that time that the appellate's intentions changed. She no longer was happy with the mortgage being satisfied. She now wanted some type of compensation for co-signing a loan. And that differs greatly from the intentions at the time of the agreement. Now, looking at Florida cases regarding partition, everyone looks usually to Condrey v. Condrey, the Florida Supreme Court's ruling that focused on the time of the agreement. Now, partition can be denied for several reasons, but oftentimes it's whether or not there is an agreement that exists that governs how the property is going to be owned, managed, sold. And it's not some later date that focuses on that agreement. It's at the time of the agreement. For example, in Condrey v. Condrey, an elderly couple receives title to a property and they place their son on the property. And at that time, both parties intended for the elderly couple to never be forced from the property. Now, there's a lot of sentimental language in Condrey v. Condrey, and that language is then used in the 4th District's case of Rose versus Hazel. And in that case, the parties of the case received title through inheritance. And whenever they received title through inheritance, there was no agreement. They received it through a will. Now, because there was no agreement in place in Rose v. Hazel, the court was unable to look and see what the parties' intentions were. Now compare that to this honorable court's decision in Smith versus Mohammed, in which case the court focused again on what was the party's intentions at the time of receiving title. Here, in this case, it's clear. There's tons of language in the final summary judgment, or not final summary judgment, excuse me, final judgment following trial as what the party's intentions were at the time of receiving title, at the time of this agreement. And at that time, the appellate wanted no interest in the property. And presumption, that's why the court ruled as it did. Now, again, the controversy in this case is whether or not the trial court should have stayed to strict contract law principles. And in this case, because partition law is more flexible, the court instead focused on basic principles of fairness. So, going back to the timeliness of the appeal. Now, there has been some argument in the initial brief as well as the reply brief about whether or not the final judgment following trial was a final order. Now, if there is some type of ambiguous language as to whether or not it was final, then this court has said numerous times that upon the filing of a motion for rehearing under 1.53, once that motion is heard and denied, then it becomes final. Now, there's also some language that we cite to in our answer brief from the 3rd District Court in Baltimore versus Condo Association Commodity, which states, as a result, once a judgment becomes final, as where A, a final judgment has been entered, and B, a motion for rehearing under 1.530 has been denied, the trial court loses jurisdiction to rehear the judgment on the merits. So the appellee's position in this case, Your Honor, is that if there was any doubt as to whether or not the final judgment was a final judgment, all those doubts were quashed after the appellate's first motion for rehearing was denied. Now, even though that motion was denied, and the motion for rehearing itself argues verbatim the same things that appear in the initial brief, mainly that the trial court ignored the parole evidence rule. Now, once that motion was denied, several months passed, and almost 1 year later, the appellate filed a second motion for rehearing and a motion to vacate the final judgment. Now, both of those motions were denied on June 2nd of 2023. So, if there was any doubt about whether or not the appellate's right to partition had been resolved, those doubts were quashed at that time, meaning that under Rule 9.110, 30 days from that June 2nd order was the latest time in which the appellate could have filed a notice for appeal in order to confer jurisdiction upon this court. I did briefly also want to touch on the reply brief, for the most part, and the initial brief focuses mainly on breach of contract cases. Now, the appellee's action in this that was decided at trial was a breach of contract case. However, the appellate's case was that of partition. Now, the focus on breach of contract cases might not be a one-to-one fit. However, in the reply brief, there are two cases mentioned for partition. The 4th DCA's O'Donnell versus Marks case and the Fernandez versus Merritt case. Now, both those cases talk about whenever a person purchases the property and receives title and places another person on the deed, such as here, there is a presumption that those funds are a gift. Now, the key language there is unless there is evidence to the contrary. And in this case, there's ample evidence to the contrary. We have an agreement that outlines some of the intentions of the parties, as well as, in this case, lots of testimony as to what the intentions were. So it cannot be argued that the initial joint purchase or joint receiving of title was a gift from Miss Nancy Sayos to her daughter, Joan. Your Honor, I know I have a good bit of time left. However, I would just like to conclude by saying that the present appeal should likely be dismissed as the position of the appellee for failure to file a notice of appeal within 30 days following the trial court's denial of the first rehearing motion. That is in the police opinion, an intermedial justicial defect that is fatal to the appeal. Now, if the court decides to entertain the appeal, the final judgment denying partition should be affirmed, as the trial court was not bound by strict contract law principles, instead focused on the fairness. And the fairness in this case is that the appellee paid all the funds to purchase the property, paid all the funds thereafter, and that her daughter should not receive a windfall by forcing her out of her property and forcing the sale just simply because of past grievances. I conclude, I'm thanking your honors for the time, and the appellee rests.
All right, thank you, sir.
Your Honor, I want to address your question about the transcript. First of all, that wasn't raised by the appellee, but more importantly, I don't think it's necessary. If you look at the pleadings, the only defenses that were ever asserted and raised in the pleadings by the defendant is the existence of the agreement precludes my client's right to a partition. He's got 3 affirmative defenses, and they just say there's an agreement, you breach the agreement, you have unclean hands because you're not complying with the agreement. Those are the only issues tried, and like I said, it's undisputed. They entered the agreement, it's undisputed my client was co-owner of the property, and it's undisputed the mortgage was not satisfied until after the obligation to date under the agreement.
So
There's
if I understand your response, then your position is the error is apparent on the face of the record.
Yes,
that's
sir.
allowing us to address.
There was no claim that there was some kind of novation or amendment to the agreement that they could satisfy it later. Okay, they seem to disregard under fairness principles. The fact that they were a few months late relieves them of their obligations under the contract, and I don't believe the law affirms that or supports that. Judge, I don't have any dispute that the final judgment after trial resolved the partition question. The reason the final judgment is not final is because it didn't resolve the breach of contract question, and specifically the issue of the damages and the issue of ownership. If you go back to the final judgment after trial, the final judgment after trial does not state my client loses her interest. It states the plaintiff's claim for breach of contract is granted, and then it says we reserve jurisdiction to determine the damages, including with the legal cost fees and including whether or not my client is quitclaim. So an important issue of damages is left remaining on the counterclaim, which is a compulsory counterclaim, and so under the law that I cited in my brief, that means the final judgment was not a final order because it didn't dispense of all the judicial labor to be done. And my client had the option. She could have done a partial final judgment on the partition action, an appeal of a partial final judgment on it, but she waited until the court rendered a decision. And doing that does not, once she appeals the final order, under the rules, Your Honor, we're entitled to have this court review all the interlocutory orders that were entered leading up to that final order, including the final judgment after trial finding that my client is not entitled to a partition.
What's the daughter's damages here?
Well, I mean, we're talking about her right to partition. She lost her right to partition,
Well,
obviously.
what's the value of that?
Well, she was.
When you said right.
Now, our position is this, Judge. The agreement.
Can I finish, please?
Yes, Your Honor.
Sorry. What is it that she's seeking? She's seeking to have the property sold, have her mom's run off and the property sold. Is that what she's seeking?
She's seeking a partition. Yes.
That's what we're talking about. Throwing mom out and selling the property.
Well, I don't know. Well, everyone lives there. I believe mom uses this as a rental property, so I think that's a little strong. But it is to exercise her rights under the agreement, which is that my client agreed to co-sign as long as you satisfy the judgment by April 30th. And if you don't, we're going to sell it. And if there's any profit, we'll split it. If there's any losses, you're going to pay them. And that was the agreement. And all she wants is that agreement.
Well, what's the harm? As I understand, things have been paid off. Taxes have been paid, the mortgage has been paid. Where's the harm to the daughter?
Well, I think the court is saying that the agreement that she should not receive any benefit from the agreement. My question to you is, if the mother could satisfy at any time, what consideration is she being given for doing what she did? You know, she's receiving zero consideration, and she just wants the agreement enforced. The mother can make her claim to recoup all the monies that she's put into the property, but in a partition action, and there can be an equitable partition. But we're not seeking damages from a contract, we're seeking to enforce. Basically, the agreement was, if I don't satisfy by April 21, you and I are joining hands. That's what the mother promised her.
But it was subsequently satisfied.
It was subsequently satisfied, and the agreement was, if it's subsequently satisfied, you keep your interest. You're a half owner with me. And she had the right to, both under the common law, but also in an agreement, to partition the property.
How long past that April date did it take to satisfy the mortgage?
It was April 30th. The first paragraph of the agreement.
So there's two different dates in the agreement.
Right.
How far past the last date?
The mortgage was satisfied on January 5 of 22. So it was approximately 8 months, 7, 8 months, 8 months, I guess, before it was satisfied. But by then, she had filed her action for partition. She already incurred the attorney's fees, retained an attorney, filed her lawsuit to have the property sold. Only then did the mother satisfy the mortgage. And so she just went forward. Respectfully, we ask the court to, review the contract. I think under the contract law principles I cited, it is clear that this was an agreement. My client would agree to co-sign on the condition that the mortgage be paid by April 30th. And if it's not, then my client would have the right to sell the property, and they would split the proceeds, if there were any, and if not, the mother would pay loss. We're simply looking, while we filed an action for partition, the rights given to my client in the contract are consistent with the partition. That's exactly what a partition does. There's a whole body of law explaining how a partition proceeds, and the partition is the court orders the property to be sold, and the proceeds are split evenly according to the interests of the parties, which is what my client wanted. So, respectfully, Your Honor, unless you have further questions, I'll rest.
Thank you.
Thank you, Your Honor.
Thank you, Counsel. All right, well, both cases are now submitted, and we'll go into, I guess, partial recess. We'll now go on to the next phase, which is to have some interaction with the students, as I mentioned earlier on. What we'd like to do is